Hi, this is Mike Moo from HipaWatchdog.com. We are a subsidiary of E2O Health, and we help you with your HIPAA security risk analysis requirements for HIPAA compliance. All right, this is a continuation of some of the series that I've been posting lately on the channel. All right, so I've taken a look at some of the resolution agreements at the Office of Civil Rights because this is really helpful and useful in knowing exactly what kind of standards they expect. Sometimes you're looking at the HIPAA regulations in the text and there are certain requirements and there are certain addressables. When you look at the resolution agreements in here, it details a bunch of scenarios, real scenarios, of course. These are all publicly on the website. You should check it out at hhs.gov. HIPAA for Professionals Compliance Enforcement Agreements. I'll have a link down below. So you can see exactly what happened to maybe some of your peers and what kind of settlement they had to do. Now, these are settlements specifically with the Health and Human Services. There are additional potential fines or fees as related to each individual circumstance, right? So today we're taking a look at the $2.5 million, number 3, $2.5 million settlement that shows that not understanding HIPAA requirements creates risk. All right, $2.5 million, April 24th. This is one of the higher settlements. Okay, it's definitely not the highest, but as you can see, just down below, we have a $5.5 million one. We'll talk about that some other time. All right, let's take a look at some of the details here. This is from April 24th, and you can go ahead and read it yourself, or if you're just listening, my guess is a lot of you are probably listening to this instead of actually watching the video. But Cardionet in April 24th had a settlement with the Health and Human Services. Cardionet has agreed to settle potential noncompliance with HIPAA privacy and security rules by paying $2.5 million and implementing a corrective action plan. So it's usually the corrective action plan that you get a lot of nice details in there, but this was the press release. Well, let's see, read the press release, and then you can read the settlement. Okay, the press release over here. So what happened was in January 2012, notice that this was over 5 years ago, and finally settlement just happened now. I often have to mention this a lot, is that sometimes it takes a while for all this stuff to catch up. And whether that's because the Health and Human Services don't have enough people, or the Office of Civil Rights don't have enough people to follow through with the investigation, or it just takes a while, right? Know that when something like this takes a while, it's also going to cost more in a lot of legal fees. Okay, well, anyway, so in January 2012, Cardionet reported to the Health and Human Services, the Office of Civil Rights, that a workforce member's laptop was stolen from a parked vehicle outside of the employee's home. Now, at this point, if you have been following up to date over the years with some of these compliance things, this is obviously something that happens quite a bit. Okay, so this happens often. People's cars get broken into and valuables get stolen all the time. And laptops are, of course, something that if a thief breaks into somewhere, these are some high-value items that they're interested in taking. They might not necessarily want the data in there, depending on what level of thief they are. But laptop is going to have a fairly good resale value. Plus, who knows what data is in there, right? So anyways, laptop contained the EPHI of 1,391 individuals. Now that's not that much. Okay. That's definitely over the breach requirements of having to report it to the website. So, and investigation, etc. But it is definitely not the highest amount that has been lost if you just look at any of the news. So that's not that much. So you might be asking, well, then how come it came out to $2.5 million? Well, the Office of Civil Rights investigation revealed that the Cardionet did not have a proper risk analysis. They call it insufficient risk analysis. And the risk management processes in place at the time of the theft. Okay. So basically, I'm sure after 2012 they had a proper security risk analysis, but before then they didn't. So at the time that this happened, that was the finding. Okay, so they didn't have that. Additionally, Cardionet's policies and procedures implemented the standards of HIPAA security rule were in draft form. That's also very common too. So, a lot of places, when they first get the security risk analysis done, they get all these policies and procedures. They're usually, a lot of them are actually template based or semi-customized. Here at HIPAA Watchdog, we also don't like inventing the book as well. So we have a decent set of templated policies and procedures that are some of the best practices that cover just generally most covered entities, right? So that's pretty common. The problem there is that it was in draft form and really wasn't implemented. How would they know? Well, because if it did, you would have had evidence of such. All right. Obviously, they weren't following policy and procedures. If they said, well, employees aren't allowed to take laptops that aren't encrypted, it's yada yada, then this wouldn't have happened, right? If it got stolen, it would not have necessarily been a breach. It was properly encrypted. They had a kill switch on it. Whatever the IT had in place. All right. So further, the Pennsylvania-based organization was unable to produce any final policies and procedures regarding the implementation of safeguards for EPHI, including those for mobile devices. That is also not, right? So because they weren't able to produce it, that's why it was found to be in draft form. Okay. Mobile devices in the healthcare sector remain particularly vulnerable to theft and loss. This is especially true and is going to be more and more true as we move along. Our cell phones are basically supercomputers compared to maybe just 10 years ago. The amount of information and processing power that we have on our cell phones is absolutely astounding, remarkable. Just every couple of years, it leapfrogs. All right. Failure to implement mobile device security by covered entities and business associates puts individual sensitive health information at risk. This disregard for security can result in a serious breach, which affects each individual whose information is left unprotected. So 1,391 individuals. I'm going to do a quick little calculation here. So $2.5 million over 1,391 individuals. So you're looking at a fine, if we're just breaking it down by individuals, of $1,797.27 as part of the settlement for this one laptop that got stolen, right? So there's a resolution agreement, and I encourage everybody, if you're online and if you're a HIPAA privacy officer or a HIPAA security officer, read these compliance enforcement agreements. It gives you first-hand account and experience of what happens and what you were expected to begin with. Okay, so here is the PDF. This is all, of course, all on the Health and Human Services website. The resolution agreement usually starts out naming the parties, et cetera, letting them know just all the Code of Federal Regulations that covered entities have to adhere to is all right here, right? And then defines Cardionet here in Pennsylvania, wholly owned subsidiary of biotelemetry. Okay. So before I continue, I should mention that I am not an attorney, so this does not constitute any legal advice, and you should seek legal counsel if you need. Okay, but these are all my opinions as a security expert here in the health-related field. All right, so factual background. Let's take a look at this. On January 10th and February 12th, the OCR got a notification about the breaches affecting 1,391 and 2,219 individuals respectively. Okay, I'm not sure what happened with the 2,200. Earlier it said 1,391. All right, so Cardionet failed to implement specifications required to establish security management process to prevent, detect, contain, and correct security violations. All right, so when you do a security risk analysis, that's what this is about. A good part of it is. It's about managing that risk. There are certain requirements that you have to do, and there are a lot of addressables that you also have to do. But one thing that's absolutely required is, of course, doing the analysis in the first place. Because when you did, you would have found out just what a big deal this would have been, because all it takes is this one time, right? It doesn't matter if everything has been great for 20 years. People know they shouldn't be taking paper records off-site, in an unsecured manner, right? We've heard of, at least I've heard of, employees taking out medical records, to bring home, or doctors, file folders, and wind blew them all away. You can't catch them all. That's a definite breach. It's not a major one because, you're unless you're in a really windy area. But it's a lot easier to have major breaches with technology, right? The thumb drives, the size of your thumb easily holds the entire database of all the history and all the records easily in the size of a thumb drive, right? Or maybe even your fingernail. Okay. So because they failed to so specifically, they laid it out right here in specifics. They didn't conduct an accurate and thorough risk analysis to assess the potential risks and vulnerabilities to the confidentiality, integrity, and availability of EPHI. Basically, they didn't do a full-on risk analysis. Okay, those checklists, that doesn't apply. Checklists are not security risk analysis, right? If you can do a risk analysis in 5 minutes and document it, that's really not a great risk analysis, to be honest. It might be one for updating, depending on how often you update it and whether or not you have a thorough one, but you really have to consider a lot of things. A laptop seriously would have been one of those basic things that they would have had to consider, because you would have to review all the devices that are being used to manage, process, delete, view EPHI. Okay. So they failed to plan for and implement security measures sufficient to reduce those risks and vulnerabilities. So here's the Code of Federal Regulations 16408A, subsection A and 1. All right. So that's where you find out about how you're supposed to do a security risk analysis. So they didn't do that. So of course the fines obviously increased quite a bit. They also found that Cardionet failed to implement policy and procedures that govern the receipt and removal of hardware and electronic media that contain EPHI into and out of its facilities, the encryption of such media, and the movement of these items within the facilities until March of 2015. All right, so it took them 3 years after that to implement these policies and procedures. 3 years. That is another major reason why the fines were incredibly much higher. Okay. Now, keep in mind, $2.5 million, it wasn't what the Health and Human Services was looking for. This is what they settled and agreed to, as long as Cardionet follows through on this corrective action plan. Okay. They have a right to ask for more, but, to be honest, they want to try to settle and do what's appropriate. That's why $2.5 million was agreed upon. And finally, C, Cardionet failed to safeguard against the impermissible disclosure of protected health information by its employees, thereby permitting access to that information by an unauthorized individual, and failed to take sufficient steps to immediately correct the disclosure. That's pretty much the whole general statement about what happened. Okay. All right, the rest of this is legal stuff. No admission. It's not admission of liability. Blah blah blah. Intention of parties to effect a resolution. Okay, so terms and conditions. There's a payment. The corrective action plan. We're going to go ahead and scroll down to that. The rest of this legal stuff, you can go ahead and read that on your own. This is pretty standard though. All right, everybody has to bear their own legal costs and other costs involved with all this stuff. Okay. Statute of limitations, disclosure. This was of course released because of the Freedom of Information Act. Authorizations. Okay, then they got to sign off on these. These were the people in charge involved. Okay, so here's the corrective action plan. This is probably one of the most important parts that you should be looking at. You should just jump right in, after you get the story, and you should jump right in to the corrective action plan. When we do security risk analysis at Hipaa Watchdog, of course, we identify a lot of these things, and we have to compare that with what's appropriate for you, right? So a lot of the work we do does have to do with private practices, and of course, if this was something for private practice, then the corrective action plans might be different. The fines would be probably different, right? But of course, this all scales, right? Cardionet is not a small practice. Okay, so keep that in mind as you think about all of this. Okay, so this is the agreement. Let's go down here, and you got to actually submit proof of whatever was agreed upon. And so they tell you that it can be made by any means: certified mail, overnight mail, hand delivery, proof that they're following through with the corrective action plan about how much time that they have and what they agree to. Okay. So this is pretty common. Cardionet has to provide a risk analysis to Health and Human Services within 90 days. Okay. So after this, hey, do another risk analysis and submit that back to the Health and Human Services within 90 days. Okay. Within 60 days of receipt of the risk analysis, the Health and Human Services will basically let Cardionet know whether or not the risk analysis was appropriate. Basically, did you do a proper risk analysis? Did you really cover the areas, or not? Right? If you're not doing a thorough one and it's not well documented, with comments and recommendations, then they can say no. That's not good enough. All right. So if you receive a disapproval saying the risk analysis was not good enough, then you have another 60 days to revise it, and this will continue until the Health and Human Services approves the risk analysis. Okay, so you gotta do it within 90 days. Keep checking back within 60. I'm sure after a while, the patience could wear thin. Okay. Therefore, Cardionet shall review the risk analysis annually, or more frequently if appropriate. This is why we say make sure you're updating your risk analysis every year. Things change at a minimum. At a bare minimum, things do change. You need to make sure it's updated. Any environmental change, operational change, those, check out my YouTube seminar on why doing security risk analysis is not a once-a-year thing. Okay, so I gave a whole webinar on that. Okay, so following an update to the risk analysis, Cardionet shall assess whether or not the existing security measures are sufficient, and revise the risk management plan, the policy procedures, the training materials, and implement additional security measures as needed. Okay, so that's pretty typical stuff. This is what we do here with you on Hipaa Watchdog, right? We give you a corrective action plan. We are your friendly auditors. We want to keep you out of the Hall of Shame. Okay, this is the Hall of Shame. All right, so develop and implement a risk management plan. And they have to submit that back within 90 days for final approval. 60 days, same process, whether or not they approve or disapprove of the plan, right? So, for instance, they got back, they identified that the laptops were not encrypted. Obviously, they weren't encrypted. Nor did they have any of the other regular security precautions. Maybe they didn't give locks to the people taking them with them, physical security locks, I don't know, audible alarm locks, fail-safe kill switches, anything to secure the computer physically and technically, right? VPNs, firewalls, antivirus, anti-malware, right? Regular penetration tests on laptops. Make sure it's up to date. Whether or not the security logging is in place. Are the logs there? Are they being reviewed? Is the laptop coming back after it's checked out and having the security logs reviewed to make sure nothing happened. Right? These are all important things to do. Okay. So same thing with the 60 days. Upon receiving any required change, you got another 60 days back and forth, and they will agree to implement the steps to mitigate the risks and vulnerabilities. That's basically what you do after you figure out your risks, right? Figuring out how you're going to mitigate them, eliminate them, transfer them. We all know you can't really eliminate all risk, right? It's a matter of bringing it down to appropriate. So there's a bit of negotiation room there. Cardionet shall review and, to the extent necessary, revise its current security policies and procedures based on the findings of the risk analysis and implement the risk management plan, with particular attention given to policy and procedures with respect to device and media controls. Yeah, obviously this was due to specifically a lack in policies and procedures with respect to device and security controls. All right. That whole thing could have been prevented. Okay, so same thing, 60 days. Concurrent providing health and human services with revised policy and procedures, Cardionet shall provide certification. Okay. When we do security risk analysis, actually, to be honest with you, when I do a lot of these remotely, with these larger groups, we go over this stuff, right? We don't ask you immediately during the analysis about providing certification that all laptops, flash drives, SD cards, and portable media devices are encrypted. No, we don't. We ask whether or not you did, and we determine with you whether or not your devices should be encrypted. And most of the time, I want to say yes. It doesn't matter if you're using a cloud EHR, guys. People download stuff on their desktop. People view stuff on their desktop, on their laptops. People save things, right? Unless you have it all configured and locked down, everything goes back to the server where it is encrypted behind a safe firewall, a physical firewall as well. Very few cases have I not seen EPHI to be found on a desktop, particularly if they've never done a security risk analysis. They just don't understand the risk. They meaning, clients or people that we've done audits on. All right. Okay. So, and other portable media with a description of the encryption methods using certification within 30 days of receipt. Cardionet's revised policies and procedures certification. HHS will inform Cardionet in writing whether or not it's approved. Okay. Or whether or not it's not approved. And then if it's disapproved, they'll have some sort of response, written explanation, etc. And make sure you get that all figured out. All right, number 3, upon receiving comments and recommendations, then you have 30 days to make changes, revisions, and modifications. Again, for review. So this time, for this part, it's 30 days. Okay, so I'm seeing 30 days, 60 days, 90 days, usually on a monthly basis. Review and revise training program. Okay, this is very important as well, right? When you get these new policies and procedures, it's really no good unless you pass them out and make sure that there is a training program to make sure that all employees or business associates, if applicable, get that training and they know the importance of this, right? They need to know that Cardionet's training program must comply with HIPAA security rule, and of course, because of their issue with what happened, it has to include a focus on security, encryption, and handling of mobile devices and out-of-office transmissions, right? Of course, they're going to focus on this. Okay. The revised training program, if applicable, shall be forwarded for its review and approval within 60 days. So it's another 60 days, 30 days on whether or not it's approved or denied. All right. Same thing. This happens a lot. If you read the other corrective action plans and the settlements, usually 30 days, 60 days, and there's this back and forth process. And let's see. Reportable events. So Cardionet shall notify HSS in writing within 30 days if there are any violations that shall be known as reportable events. And that includes a complete description of event, relevant facts, persons involved, provisions, policies, and procedures implicated, description of actions taken, and any further steps Cardionet plans to take and address the matter to mitigate any harm and to prevent it from reoccurring. Okay. This is also very important. After you do the training and after the policy and procedures are set forth, you need to enforce them. Okay. When I go somewhere on site and I ask whether or not there's been any sanctions or any reports where workforce members fail to comply with policy and procedures, it's often surprising to me that they don't have such a thing. Even clinics with 60, 80, 100 to 200, really, you don't have any sanctions? You don't have any reports about workforce members not following appropriate policies and procedures? I find that extremely surprising, because when I go on site and I see things that are definitely not what a general person just visiting would consider to be appropriate policy and procedure. Okay. So it's really important that you enforce them, that you have those sanctions in place. All right. And then you have the whole anti-retaliation policies. Make sure that that's all in the training. Let them know. Okay. It's almost like see something, say something. All right. So anyways, they're telling Cardionet that if they see something about workforce member that's not following through with policy and procedures, you got to have it all documented, reported back, right? And obviously, you're going to want to take appropriate action shortly after that happens. Okay, annual reports. All right, so that's another thing here that is agreed upon often, is about the regular annual reports and reporting periods. That you gotta make sure that you're not just sending us this paperwork and not really doing anything after that, right? So there's a 1 year period that will be referred to as a reporting period. Cardionet shall submit annual reports with respect to the status and findings regarding the compliance no later than 60 days after the end of the reporting period. And here's what you need to include: description or any changes, summary of Cardionet's strategy related to the assessment of the potential risks and vulnerabilities to confidentiality, integrity, availability, EPHI to Cardionet, identification of all outside entities assisting Cardionet in this process, documentation related to security measures Cardionet implemented or is implementing, if any, to sufficiently reduce the identified risks and vulnerabilities. And you have a detailed description of any revisions to policy and procedures and training materials. Summary of the reportable events I just talked about. A summary of the corrective action measures taken during the reporting period. And finally, an attestation signed by the owner or officer of Cardionet attesting that he or she reviewed the final report and made a reasonable inquiry. Okay? Reasonable inquiry regarding its content, and believes that upon such inquiry the information is accurate and truthful. That's important. Very important. Document retention. Keep this corrective, all this stuff for 6 years. Breach provisions, fully timely written requests for extensions, 5 days prior to the date. Notice of breach, intent. Okay, so let's see. What else? Cardionet's response said they have in compliance. The alleged breach has been cured, cannot be cured within 30-day period. Pursuing such action, 30-day, okay, blah, blah, and then they have to sign it. All right. So does that give you a good idea of what happens at the end of the settlement? This is probably the best case scenario that they could hope for. And that's why they settled on it. All right. I want to take a little moment here to mention that the same thing here with the laptop applies with your cell phone. Okay. Believe you me, we're going to see a lot of these things happening with cell phones. And you definitely want to have a mobile device management plan or system in place or policies and procedures, even if it's no work-related stuff on a cell phones. You're not to bring a cell phones in. That might be unreasonable, right? Given the size of an organization, and if you want to try to retain the best employees, that might not be reasonable. It really might make sense to come up with the whole mobile device management plan together and how you handle BYOD, or whether or not you provide devices and how you lock them down. These are all things that we talk about during our security risk analysis, if need be. Okay. So if you're subscribed to Hipaa Watchdog and you're listening to this and you're going, Mike, I know we kind of went over this, but I have some concerns. Hey, schedule that with me, right? Let's talk about, let's figure out something that works for you and your employees. Okay, what's reasonable, what's appropriate. Most of the time I say, and I even give you a tutorial for small practices to enable encryption on your computers. On all your Windows 8 Professional, Windows 10 Professional, if you're running Windows 7, my recommendation is, hey, let's upgrade that, right? Because Microsoft is not focusing their efforts at all on patching Windows 7. Why? Windows 7 came out a really long time ago. Windows 10 is the future. That's what they're working on. Windows 10 and beyond. So running Windows 7 is a security risk. Okay, that's something you got to assess. How bad is it? Is it worth sticking to it, or is it better just to get a new computer and operating system? Right. My guess is, for most places, and I usually recommend it, upgrade. Do the upgrade. It's about time. You don't have much time left before, for sure, it's not HIPAA compliant. Okay. So, what could have prevented all these things? All those things in the corrective action plan could have prevented. If they did a security risk analysis appropriately, and they had those policies and procedures, they trained them, and they had those policies and procedures and how you check in and check out equipment, what's appropriate to bring in and bring out. Guys, all it takes is one spreadsheet to get out there. Just one. Right? That one spreadsheet could contain the names, addresses, phone numbers, social security numbers in that spreadsheet. It's just maybe a couple of megabyte file. And that could result in this $2.5 million settlement fee. Not to mention all the other stuff they got to do in terms of credit reporting, contacting everybody, the support calls, credit monitoring, right? Reputation loss. Not worth it. Not worth it. All right. So I ranted long enough about this. I read about these things and I look through all these resolution agreements so that we here at Hipaa Watchdog can better guide you through reducing all these risks and knowing more specifically what Health and Human Services expects out of you at a minimum, right? That's what it's all about, reducing risk to an appropriate level. Okay, that's it for this video. If you have any questions, please feel free to comment down below. You can tweet me. You can find me on LinkedIn. If you are Hipaa subscriber, Hipaa Watchdog subscriber, click that schedule meeting, and you can have this little meeting with me, 10 minutes, 15 minutes if you like, or we can let's finish. Let's everybody finish up that security risk analysis the sooner rather than later. Okay, it's no good if you finish the security risk analysis in 2014 when you had a breach in 2012. No, sorry, in this case it was 2015. 2015. Finish the security risk analysis and implement policy procedures when something happened in 2012. That's really bad. All right. Thanks for watching or listening, and I will catch you in the next video.